Article 267 Reference Procedure by Camilla Chadha. In order to understand what exactly is an Article 267 reference, we need to look at how individuals enforce the law, i.e. EU law. They have very little contact with the ECJ because they have to enforce the EU rights within their national courts. So, to understand the real interpretation of the EU law and the rights it prescribes, and to ensure that justice is served to the EU citizen, the court can ask a question to the ECJ on how to interpret the EU law, and this is called a reference, an Article 267 reference, coming from the TFEO Article 267. And the answer that the ECJ gives to this question is called a preliminary ruling, because it before the case has been ruled and decided on, it tells you how the law has to be interpreted, which is then left to the national courts to apply in the particular case. Now, this procedure is quite limited because the ECJ can't force the national court to make a reference. So the litigant might seek to try and establish a case in state liability if the court doesn't make a reference. Like in Kobler, this is what happened when it was in relation to an Austrian mandatory court. But this is likely to fail because it's hard to prove that this is a sufficiently serious breach. How do we make an Article 267 reference? Well, we have to begin by establishing that the body who wants to make this reference is a court or tribunal, otherwise they couldn't do so. And further to that, you need to show that the point on EU law that you're sending for reference is actually necessary, because if it's not necessary, you can't make a reference. Then, depending on whether the court is mandatory or permissive, it will tell you whether the court is actually obliged to make a reference, or is this a decision that they're taking, and on what grounds do they take this decision. And finally, you have to consider that there are circumstances where the ECJ may reject a reference. How can we decide whether the body in question is a court or tribunal? Well, the criteria was set out in Dorsch Consult 1997. This case concerned a federal supervisory board, and what we will do is we'll look at the factors in relation to two cases: the Broekmeulen case where the appeals committee of the Dutch medical profession was established as a court or tribunal, and the case of Noordzee where the court was the arbitrators actually in fact were not decided as a court or tribunal. The first factor is whether the body is established by law. So, for example, in Broekmeulen, the actual body had authority and assistance from public authority with the backing in a legal framework, which made it a court or tribunal. The second one is the body permanent? So, for example, membership of the Broekmeulen case, the court it concerned, included ministerial appointees who had been there for a long time, unlike in the case of Noordzee. The third factor is the jurisdiction compulsory. So with the Broekmeulen case, the decision that was made was binding and it was not subject to appeals in any ordinary court. This can be contrasted to the Noordzee case where the arbitrator was not deemed a court or tribunal because the ECJ stressed at the voluntary nature of the arbitrator's jurisdiction and the fact that people did not have to go there and their decisions would not be binding as such. The next factor is a procedure inter partes. We'll get that from the facts, so is essentially are all the parties present and heard just like they were in Broekmeulen. Then the next factor, does the body apply rules of law? Well, that's fairly straightforward. And finally, is an independent body. So in Broekmeulen, it was independent and yet it was not subject to appeals and the decision was binding, and that's what made it a court or tribunal. In Dorsch Consult, it was also found that the Federal Supervisory Board was a court / tribunal. And what they said is it was sufficient that a number of factors had to be met, or not all 6 are required to be met. After the body has proved itself to be a court or tribunal, it will have to show that the reference is actually necessary. Now, what makes a reference necessary isn't directly answered, or there's no clear guidance given. But the Chilfit case, now this provided a criteria of what is not necessary, making us able to infer, therefore, what would be necessary. So, where will Article 267 reference not be necessary. The first is if the reference is not relevant to the conclusion of the case. Second is if the ECJ has already dealt with this reference, as had happened in De Costa. And finally, where the correct application of the law is so obvious as to leave no scope for any reasonable doubt as to the manner in which the question is raised. This is in essence the doctrine of acte claire, which was established in the Costa case, which basically said no reference will be necessary if the National Court considers that the EU law in question is clear and free from doubt. That was a criteria for sending it to Article 267 reference. But does the court actually have to? Is it obliged to make a reference? And the answer will depend on whether the court is mandatory or permissive. A mandatory court is the one whose decision cannot be appealed, is basically the highest court of that case, and this was made clear in the case of Costa. And a permissive court then is anything else, any other type of court, which is not the highest court for the case to be appealed to. Mandatory courts, i.e. courts that are the highest court for that particular case, are obliged to make references. They have to, and a failure to do so may result in potential action for state liability, as was in the case of Cobbler that we discussed earlier on. Courts, on the other hand, are not obliged to make references, but they do have discretion, so they can if they want to, but it's all actually in their hands whether they want to or not. However, whether they do or not should be determined by certain factors, and these are the ECJ's information note, Lord Bingham's commentary, and the Court of Appeal's commentary. So let's start with the ECJ's information note. What they say is that if there's a new interpretation or novel facts that have come before you, then definitely send us a reference. And if you're doubtful about the validity of EU law, then you must send us a reference, because no national court can declare an EU law invalid, as was highlighted in the case Photo Frost. And furthermore, they said it makes sense for permissive courts to send us a reference because it's usually the court of first instance that makes the binding decision, which isn't appealed, as was highlighted in Irish Creamery. And finally, they give instructions to ignore what the higher courts may say, as was in the case of Re-Mullen. Lord Bingham was very pro sending the ECJ references, because he said they are the experts on EU law, and usually the interpretation is critical to the outcome of the case. Whereas the Court of Appeal, they said courts should be restrained and not send it, because they don't want the ECJ collapsing with a wide caseload when some of these references don't even have a wider application than the case in front of you. Having received a reference, the ECJ may in fact refuse to make a preliminary ruling, i.e. answer the questions sent by the National Court. And some of those grounds include where the reference requires an interpretation of a national law. So in Costa, the national law conflicted with the ECJ, so what the ECJ did was reformulate the question to make sure it was just focused on EU law and it didn't have to give any comments about the national law. And the second situation is where there's an absence of a genuine dispute. So in Foglia and Novello, the parties actually conspired to get a ruling from the ECJ that the French liqueurs tax system was a breach of EU law, and the EU is not going to use the Article 267 reference procedure, where there's an absence of a dispute. They are only going to do it where it's critical and necessary to the case. And finally, where there is insufficient information about the facts or the national provisions concerned, these references must be written with due care. Otherwise, if they accept it and they do issue a preliminary ruling, this binds all member states by virtue of Article 4.3 of the TEU. Thank you for watching.